Well, good morning, and welcome to the Federalist Society Conference on the all-important book, The Antitrust Paradox. I want to thank you all for coming. I'm Dean Reuter, Senior Vice President, General Counsel, and Director of Practice Groups at the Federalist Society. I can say seldom, I think, has a discussion of a book that's more than 40 years old and its central thesis been more timely now that we are faced with what might be described as an ascendant notion of big is bad, challenges in technology and antitrust, and on and on. I want to thank Bob Bork, Jr., not only for being here today with us, but for his efforts in republishing The Antitrust Paradox, now available online everywhere. At a very reasonable cost, I'll add, as compared to the $800 or $900 you could have spent for it 6 or 7 months ago. And that runs against my own self-interest, as I have several copies of the old edition, which I guess now have gone down in value. I haven't looked. The day's events are described in your program at the registration table, but just to recap or predict, we begin here in the stateroom with a fireside chat, followed by a panel discussion on the history of the antitrust paradox and the consumer welfare standard. And then we'll move to the East Room for lunch only, and then return here for our second panel, Where Do We Go From Here? And a closing address by Senator Mike Lee, who wrote the introduction for the new volume, and a book signing. The fireside chat, of course, is going to be led by Judge Douglas Ginsburg and feature Bob Bork. They're so well known to everyone in the room that I'm going to introduce them only very briefly. And I'll say only that Judge Ginsburg is the long-serving now senior judge on the D.C. Circuit Court of Appeals, but so much more than that. A friend of the Federalist Society, a scholar, and a student of the law generally, and antitrust in particular. Bob Bork Jr. is his father's son. He's worked diligently to bring this book into print. He's absorbed so much of its knowledge, and he's now become its happy promoter. Welcome to both of you.
Thank you, Dean.
Doug?
Bob, before we talk about republishing the Antitrust Paradox, I think it'd be useful for everyone to know a little bit about the first publication of the book, how it came about, the timing, and so on. So could you give us that background?
Well, sure. My father started thinking about antitrust when he was a student at Chicago and was a student of Aaron Director.
Class of 53, I believe?
Yeah, 53. And went on to practice in antitrust at Kirkland and Ellis in Chicago. I believe he decided to become an academic after spending 7 years on the True Temper golf shaft case. He decided that was too long for any one person to spend on anything like that. So he was recruited by one of his lecturers at Chicago, Ward Bowman, who is now then at Yale. Teaching at the law school, the only economist on the law school faculty. So he started writing, thinking about the economics and the law and economics of antitrust there. Started really deciding to work on a book after a series of articles. I think one of the first was Columbia Law Review on the goals of antitrust. From there, he started working on a draft. I remember actually as a young boy at 61 Huntington Street in New Haven, he was up in the attic with working on a desk, a cramped under the eaves office, working on a desk made from a door that my mother made with his mechanical Scripto pencils and yellow pads and room full of cigarette smoke. Working on things and teaching himself calculus so that he could do the economics necessary to flesh out his thoughts. I was up there helping him grade law school exams on the blue books. And by that, I mean I wasn't reading them and offering scores. He would write the scores on the front of each blue book, and I would add them up. I learned how to do my decimals that way. And some people probably would have done better in law school if I hadn't done that. But so he he thought that it was important that that he understand the economics, and so he taught himself calculus, as I said, and started working on the book, and had a draft. Well, we went to England on sabbatical, 68, 69, and he worked on it there. So actually, just to jump ahead for a second, when we started putting this edition together, we found English spellings, because I think he had someone typing up his notes, his manuscript. And so somehow or another, they managed to miss the English spellings of words, and we've now corrected that to the proper American English. But he spent that time there working on the book. And then two things happened. One, my mother became very ill, and he stopped working on it. And two, he was back at Yale, and Yale was rife with dissent, and people were burning books at the law library at Yale Law School. And there's a famous picture of him on the New York Times front page, sort of standing and looking at a pile of smoldering books on the street in front of the law school. And then he got nominated by Richard Nixon to be Solicitor General, and felt that he really could not publish this book when he was going to be the third ranking officer of the Justice Department, and people in the Antitrust Division would somehow feel intimidated or something by having him and his book be out there.
Well, indeed, he might have had to defend certain cases in the Supreme Court that he thought were wrong, because the department had not yet turned around. Right.
That's even a better point. So he went off, had his time at Justice, which, as you know, was turbulent. And when he came back, he finished the book and got it published in 1978.
The remarkable thing to me about the next step in the story is that here it is, published in 1978. And in 1979, Ryder against Sonotone,
right,
the Supreme Court says in the decision, the Sherman Act is a consumer welfare statute. Footnote, Bork, the Antitrust Paradox.
A year later,
an extraordinary event. I mean, ordinarily the ideas in a significantly revolutionary book take a while to penetrate. And this was adopted by, I think, a very eager Supreme Court, anxious to have some kind of rudder, some standard by which to judge these cases.
Well, I think you mentioned in this very room in 2007, when they did a panel on, or a whole day on my father's contributions, that there was another case before that where the Supreme Court implicitly adopted some of the thinking, not from an article. It may have been that same Columbia article with Ward Bowman, I forget.
Are you thinking of...
it was a Ninth Circuit case.
Sylvania?
Yeah.
Yeah, GT Sylvania.
Right. So it was kind of teed up a little bit, I think.
Yeah.
But the book gave the court exactly what it needed, a rationale for thinking about antitrust that it didn't have before.
But I think Sylvania was 77, so it had to have been based on an article rather than...
Yeah, it was right. It was an article,
yeah.
I think. You mentioned. I think you mentioned in a 1967 article that 10 years later was influential there.
Yeah. So here is all of a sudden he sees his book adopted as authoritative in a way that I'm not sure whether it's clear how significant the implications of that would be when the court first did it. But one case after another seemed to have proved that was exactly what the court wanted to do.
I think it's been cited in something like 150 cases now. Not all Supreme Court cases, obviously.
Well, the court proceeded just in the line of cases, starting with Sylvania, GTE Sylvania, started systematically overruling all of its vertical restraint cases. It took 40 years to get to 2007 with Legion, the last one to fall. But I think there were 5 in the series when they just repudiated their own prior cases. based on these insights.
We should have trophies, for.
So notwithstanding that extraordinary reception at the Supreme Court and sustained application of it, the book goes out of print, and what else happens?
Well, in 1993, there was a second edition in paperback. Yeah. And there was some discussion in my father wrote a new foreword or afterword, I forget which, sort of commenting on what had happened since and feeling, I think, pretty good about where things were going. So a couple of years ago, actually about 3-4 years ago, I began hearing rumblings from people like Elizabeth Warren and others about redoing the antitrust laws, and we have to use antitrust law to impose, to break up companies that are too big. And I thought, well, I wonder, can you still get the book? I hadn't looked, and I went online, and Dean said it was true. You could buy old copies of the book for several $100s, but the 93 version was out of print. In paperback, they were still expensive. So I called the publisher, and they wouldn't talk to me. I had to hire an agent to talk to the publisher, and I had to hire a lawyer. So ultimately, we were able to convince them that they should give up the rights of the book to the Bork family, and then I started looking for a publisher.
The original publisher didn't want to bring out the new edition?
No. I won't name names. But, the original publisher the original publisher had been many times oversold. And, and I think the current publisher was now the parent of that in many other imprints. So we started looking around, and there was some interest. But I guess the way of the publishing world is we have to have a lot of meetings. We have to have meetings to discuss whether we should have another meeting and another meeting. And one of the last publisher I spoke to said it would take about 4 years to get the book out. And they didn't really have the marketing depth to handle it. I said, well, he's a household name. It's not like he's unknown, and it's already been published before and did very well, and it's been very influential, so it shouldn't be a problem. And they said, well, it'll take about 4 years. So I decided to start a publishing company, and now I'm a publisher. I feel like Orson Welles.
Well, your father would be very glad.
And so we published it, and took a lot of work, actually, to clean it up. There were, as I say, besides we went through every citation, made sure they were all up to date, they're all correct. I had John Shue, a good friend of the Federalist Society and of mine, sort of honchoed as a kind of a managing editor. Dean Reuter, who I cannot go without saying how important he was to making this happen, because he kept prodding me and to get it done and providing help. And at the very end, I hope some of these guys are watching, there were 12 Harvard law students who were recruited to do the final read-through, make sure everything was fine. And we gave them one week to do it. And they were all taking exams, I think, at the same time. So they deserve a lot of credit for that, and as does Dean. So we got it done, and I have a publisher, Ingram Spark, or a printer, and they print them on demand, and Amazon and Barnes & Noble have them now in hardback, paperback, and ebook version. And we may come out with a large type version at some point down the road.
Well, that's great. Well, Gene, of course, is a good source of advice because he had brought out his own book,
Yes.
Hidden Nazi, but a good book.
We should hold that one up
at the right time.
Right.
By the time you were, I want to ask you about the revisions. Is it indicated by the font or in some other way what is new material, like updating?
It's indicated by. The new material is kind of limited. I mean, it's important. We have a new introduction by Senator Mike Lee, and a foreword by me, and then everything. And there's some new acknowledgments, but everything else is the original book. and the original two editions. We have included things that were new in the 93 edition in this edition, his epilogue and that sort of thing, and his acknowledgments. And
That's great. So by the time the book had gone out of print, the influence had, of course, gone well beyond the Supreme Court's cases, because starting in 1981, the Antitrust Division and the FTC basically adopted the same principles. Bill Baxter, 1981, not long after being confirmed, says, big is not bad, bad is bad, which would seem to be, fairly anodyne, but in fact was a major shift in policy. And Baxter was, of course, schooled deeply in the book. So, would you say, in view of the long passage of time, that the lessons have become frayed in the courts or in the enforcement agencies?
Well, they are now.
What are you seeing?
Well, the FTC, I think, is about to change its guidelines on vertical mergers.
They've rescinded the previous
rescinding the previous memo.
Issued guidelines, right?
Rescinding the previous guidance. Not sure what Justice is doing at this point, but everybody should read a speech by the Associate Attorney General on antitrust that was given yesterday, I think, or the day before. And they now view antitrust at the Justice Department, and I think in Congress to a great degree, and also at the FTC, as being about something more than maximizing consumer welfare and efficiency. It's about economic justice, broadly writ, and she goes on for some pages about what she thinks we ought to be doing with antitrust. But basically forcing companies to adopt woke policies. So there's antitrust is under assault now. It's they're trying to weaponize it for more control and more regulation of business and the economy. And as I've said in many interviews, I'm very concerned that they're trying to basically fossilize capitalism.
Well, suppose the department brings a case that's based on some consideration in addition to or other than consumer welfare. Economic justice is the one you mentioned. How will that fare in the courts, do you think?
Well, I think that I would ask you, but maybe you can't say. But
well, I don't know, but I thought you might know.
my only hope for the continued longevity of the consumer welfare standard is the courts, because they have a long history, a long jurisprudence now of deciding cases based on the consumer welfare standard. If that gets rewritten by statute, then all bets are off, I think. So.
Well, yes, if the statute changes, of course, the courts will follow the statute.
Right.
But you were implying at least that the department currently could, quite apart from any legislative change, bring a case based on something else.
They could. And the question is, how will the courts treat it? And I'm hopeful that the courts will uphold the standard that has been in place for the last 40 some odd years.
Well, in which case legislation would be the moving vehicle for changing it.
That's the risk to the current system, the current regime.
Mm-hmm. Mm-hmm. Understood. Okay, so there is not a confirmed person with the Antitrust Division. The Federal Trade Commission has, I think they have one vacancy, but in any event.
Someone's been announced now.
Okay,
yeah.
But they have, that's right, just yesterday, or 2 days ago, a professor from Georgetown. But they have new leadership even now.
Mm-hmm.
So apart from rescinding the vertical guidelines, what do you see coming out of the FTC?
Nothing good. Well, what I've seen and read so far is that the move is underway to give the chairperson, a sort of unfettered control over everything. As I understand it, the chief administrative law judge has basically had their powers subsumed by the commission itself. They can overrule, I think, easily just take over cases. If I'm misstating that, I apologize, but that's what I read. I understand that Lina Khan ordered the staff of the FTC not to speak publicly anymore, not to go to conferences, at one point not to teach classes. I think that was one of the great benefits for the staff of being at the FTC, was to go out and talk about antitrust and consumer things. And I'm told by people on the inside that has created a lot of anger, and that people are going to quit. People are quitting, and that's in order to allow her to fill the ranks with loyalists, people who agree with her. It was an attempt to push people out. And then of course now they're talking about rescinding the vertical guidelines, and I think there was even a memo on the consumer welfare standard that got rescinded as well, or at least they're discussing that.
I haven't seen that, but I'll take your word for it. The commission, the FTC, of course, enters into many more settlements than it does litigation.
Right.
And even, let's say, during the Obama administration, there were several settlements that, with respect to the enforcement of standard essential patents, for instance, in which companies agreed to things that they could not have been forced to do in court. But of course, those settlements don't constitute precedents either.
Right.
So I would think that that if there's a change in the wind at the FTC, it would be expressed first in settlements where the agency has great leverage. The respondents have great incentive to settle things and move on, particularly in merger cases, but also in consumer protection cases. And that one would see the agency's position evolving primarily by reading settlements, seeing settlements.
But they're also apparently telling companies that the settlement, they may come back and revisit some of those settlements. That they, for example, in they're after Facebook for its purchase of WhatsApp and Instagram. The things that they agreed to, and now they're saying, well, maybe not.
Right, but the complaint there doesn't rest entirely on revisiting those acquisitions. It's couched, I believe, in terms of the acquisitions having then enabled the company to do things that were anti-competitive. So this post-acquisition conduct is, I think, the more promising part of the case for the commission.
And separately, of course, they've announced now that the 30-day, if you apply for a merger, I guess, and then if the 30 days goes by, they're not going to adhere to the 30-day deadline anymore.
Right. I think the chairman has said, Chair Khan has said that the volume of applications, of filings under Hart-Scott-Rodino is just such that they cannot be dealt with in a timely fashion, given the current staffing level at the commission.
Right.
I think
I guess
she's correct that this is an unprecedented level of transactions.
I guess people are trying to get in before bad things happen, but
well,
before the rules get changed too much.
If that's the case, then good reason to say, don't count on it.
Right.
So what other than consumer welfare do you think, you mentioned economic justice, whatever that may mean, what other things are you worried about getting attached, either legislatively or through enforcement decisions?
Well, I'm just worried broadly, and I think my father would be too, to returning to a time when there is no, as you put it, rudder. There is no standard. Back in the days of Big is Bad and small actors and worthy men. I mean, just the neo-Brandeisians, as they refer to themselves, and this new stuff that's brewing on Capitol Hill, basically mean anything goes. I mean, I don't know that any company will have any idea what it's allowed to do, and will have to come looking for guidance all the time, and then may just walk into a buzzsaw if they have a merger or an acquisition or.
Well, I think the merger standard before the change of heart that came with the book was identified by, I think it was Justice Stewart in a separate opinion, right? Mm-hmm. The only consistency is that the government wins.
Right.
Now, that seemed to have been the case, in fact, because mergers, here's a problem, Bob. There are merger cases on the books from the Supreme Court. The most recent one is 1974, and I think it was Grinnell. In any event, it was 1974. It was not a terrible decision. All the previous ones are still there, Vaughn's Groceries and Pabst Brewing and all that sort of stuff. And the court has not had a substantive Section 7 case, or resolved it on substantive grounds anyway, since 1974. So all those old precedents are there. Brown Shoe is another one. When I was Assistant Attorney General, I simply would not allow the staff to cite those cases. You know, yes, they said, well, we could win. Well, if we don't want to win on that ground, all right, if we can't have a legitimate or well thought out objection. But those are the precedents, they're still there. Mm-hmm. And I don't see any barrier to the division or the FTC relying on them. They're totally out of step with contemporary industrial organization economics. But that's not the law. So maybe the consumer welfare standard isn't so well lodged.
Maybe it's not. It certainly seems to be precariously perched at the moment.
Yeah, well, particularly with regard to mergers in that respect. What besides it being harmful to consumers, what's wrong with departing from the consumer welfare standard? And adopting whatever it is, let's say a concern for labor monopsony. A merger might result in the merged firm having a monopsony position in its local labor market.
Well, let me ask you that, because I'm not sure I'm able to answer that specifically. I would say that if we start with the consumer welfare standard, yes, there are other things which may be of concern, and certainly, looking at price fixing and that sort of thing, that harm consumer welfare. I guess are workers consumers is a question. Are they consumers in the sense of the consumer welfare standard? But I would like to ask you, since you're far more expert on antitrust history and law.
Well, I'm somewhat sanitized, sterilized.
Yes, I know.
But there are a lot of different criteria that have been proposed. Mm-hmm. Taking account of labor markets and beyond that, the effect on employment as a concern, right? Just the merger resulting in redundancies and layoffs, which are harmful to individuals, is one thing that's been suggested. The environmental consequences of a transaction or of a practice, if it's a unilateral case. Those are all things that are of concern as expressed in other policies of the government.
Right. Other policies of the government. And there are laws on the books to deal with, I assume there are laws on the books to deal with labor issues and environmental issues. And
right.
But is everything that happens in a merger an antitrust issue? Or is it, we have environmental reviews of, pipelines and other things. And, so do we have to, I guess going back to your earlier question, the thing that I worry about, and again, for those of you who don't know, I'm not a lawyer. I just play one on Zoom. And and I claim my law degree as a participation trophy at the dinner table growing up, but that's about it. So some of Doug's questions, I'm thinking back to my law school days, and I didn't have them. But I did read the book. So I am concerned that we stray too far in taking antitrust to be the solution to everything. Every problem that is perceived by policymakers. What's an antitrust problem? We can use antitrust, whether it's breaking up big tech companies or breaking up big ag companies, or because we don't like what they're doing. Is it really an antitrust problem, or is it some other issues that we need to address? Write laws directed at the particular problems that concern us, and not just simply think, well, we have the bludgeon of antitrust to use to force changes in behavior and changes in company structure.
You mentioned, you made a reference to Brandeis, and I presume the neo-Brandeisian view now somewhat in vogue, and to big being bad, or maybe I introduced that to the discussion. But I'm not sure that there's a single all-encompassing theory or objection that is being presented as the alternative to the consumer welfare standard. The consumer welfare standard is a theory of everything, right? I mean,
right.
It says all these issues can be addressed with this in mind and in a fairly rigorous way. Not that it will be so clear in every case that there's no room for litigation, obviously. That will happen, disagreements about it. But the disagreements will be narrow and disciplined, based on the economic model. I think the principal motivation, I may be wrong about this, I think the principal motivation uniting the opposition to the consumer welfare standard, at least in large part with regard to scale, is that big companies that may be very efficient and may be serving consumers well obtain a political influence that is untoward for a democracy or a democratic republic. And I'm not sure that there's an answer in the consumer welfare standard to that objection. It's an empirical question as to whether it's true, but assuming it's true.
Right. Well, again, assuming it's true. I think Dad talks in the book about, speaking of democracy, that the consumer welfare standard is, first of all, a neutral principle. It's not Republican or Democrat, conservative or liberal. And he says it's a democratic, small d principle. It's based on the idea that, to some extent, that consumers decide what they want and what they like. And if it benefits them, they will reward the company that is, or companies that are making or offering a service. And if they don't, they won't. They'll vote with their feet and their dollars. So to a certain extent, I think that small d democracy should trump at least some of the democratic objection to what companies do and how they and getting to the question of size and accumulation of power. I think from what I've read, a lot of the criticism doesn't really understand the modern marketplace for things like the internet. What the economies of scale and that sort of thing that the internet provides, and just think the bigger some of these companies are, the better the consumer is served by them. Now, there are questions of privacy and the use of the information that the consumers offer up, And one can ask whether or not all of that is always understood by the consumer. But again, I'm not sure that requires, if you break up some of these companies, particularly the big tech ones, what are you going to get? You're going to get services that either go away or are going to start to cost. People are going to pay for them. They're not paying for them now. And Mark Zuckerberg will get very much richer in the sense of John D. Rockefeller got very much richer.
I think it's a very important question as to what would likely happen.
Right.
One interesting possibility is that assuming, and I think correctly, but let's assume that what the companies are doing is trying to satisfy consumers in order to profit from doing so.
Mm-hmm.
So take the objection that, well, in order to please consumers, they have algorithms that send them news and information of the sort that they will find pleasing, right? So you get this dichotomy of what people are seeing and reading, and so contribution to polarization of political view. So let's say the company that's doing that is broken up into several separate competitors. Well, they're going to compete even harder to give consumers what they want, and even more, try to send them the news that they value, that they want to see. Why would they not? If they're trying to please consumers, the current companies are doing that, presumably they are, so would their successors.
Right, and I think the current critics forget that there are, in fact, competitors out there. First of all, some of these companies compete with each other, these big ones. And then second of all, there are the Parlors of the world and others like Parlor are out there offering different services, different kinds of services with different standards of community standards and all that. I get ads in my feed all the time for apps that will give me news that is unfiltered or isn't biased or whatever, either way, or news that is inclusive of both sides. So there is, in fact, I think there are places people can go to find an alternative to what they think is they're being managed by the platform.
The array of things available is so vast it dwarfs anything in prior human experience.
Right. Now, just because some of those apps aren't as big as Facebook doesn't mean that they won't be. I mean, Facebook killed a competitor years ago in MySpace, and Google beat up Yahoo. So there's no reason to suggest that they couldn't actually also find themselves in a similar boat later on.
I want to go back to just something you said about doubting that some of the critics of the current standard maybe don't understand the economics. But there may be some who have that disability. I was on a panel, it may have been in this room, about 3 or 4 years ago, with somebody, I think, from the Open Markets Institute, who understood the economics just as well as you or I, but had these two objections, one of which was political influence, and the other of which was basically nostalgia, talking about the effect of Walmart on main streets, on the main street in smaller cities, and how it's devastated small shops and so on. It's a sort of a cultural objection based on a preference that has nothing to do with the economics or with consumer welfare. It's just saying that wouldn't it be nice to be a sort of more Jeffersonian society again?
Sure, dysentery and poop in the streets, right, exactly.
Well, I think it's a very elitist view, actually. But
well,
because Walmart's where it is because people wanted to save small amounts of money because they need to.
Walmart is where it is because my grandmother, my father's mother, who used to wonder why the corner grocery store didn't have as much in the way of choices and had higher prices, why that was. And then she said, I go to the supermarket because of that. I go to the big box store because of that. So yes, she found what she wanted, more choices at lower price from a bigger competitor. Yet she was nostalgic for the corner store. And I guess we're all nostalgic for those kinds of things, but
Right.
I'd rather pay less and have more choices.
There's an argument that it's sort of a tragedy of the commons, right?
Mm-hmm.
Everyone would like to have both low prices and the community virtues of small shops and so on. But we can't have both.
No, you can't.
So the people have chosen, I guess, is one way to look at it.
That's the little d democracy we're talking about.
Yeah, and perhaps some elites would choose otherwise, but so be it.
They can go to Martha's Vineyard.
Yeah. So are you going to be promoting the book outside of this small circle here?
Oh, well, I have. I've done probably close to 50 radio interviews. I've done half a dozen or more webinars with different organizations, and flew to Idaho recently to give a presentation at a panel. And I did one with Senator Lee, or two with him. And he'll be here later today to talk about the book. So
you have more scheduled?
More scheduled.
Right. Well, I know getting those media tours, where you sit in one place and you do a radio interview and 3 minutes go by, you do another radio
I haven't
interview.
done that. I sit in my home office and with the little camera on top of my laptop and do it that way.
Yeah, we can do it with TV too.
Yeah.
Right. It's sort of a peculiar role in which to be cast for a short period in one's life. All of a sudden being on all these media. Well, we have about 18 seconds. So I'm going to take that time just to remind everybody that when we break, as we will in 12 seconds, there will be a 15-minute break, and then we'll reconvene here for the first real panel discussion.
Thanks, Doug.
There it is. Thanks, Bob.
Thanks, Doug. Appreciate it.